Hi guys, so this is Sarah Williams with Midnight Greenery, CEO of Midnight Greenery. Today I wanted to talk about the Set 2 of regulations. So we're going to cover the first 10 pages of Article 1, which is Chapter 306 in the regulation of the marijuana industry. It looks a little bit like this. In the comments you're going to go ahead and see the link to go directly to the document so you can download them and follow along with me. So this particular section covers things like licensing fees, local option, license required, license restriction, license conditions, application for new license, application procedure, all of that stuff. So today we're only going to cover the license required, the license restrictions, license conditions, and maybe a little bit of the application for new license. So on page 1, kind of breaks it all down. Page 2 covers the license required. So page 2 covers that we're going to have 4 licenses: a retail, a cultivation, a production, and a testing license. So at this moment there's no licensing for social clubs, for ancillary services. It really is what ballot measure 2 said, which is retail, cultivation, production, and testing. So that's what is covered in 3 AAC 306.005 for that. Then we move into 306.00010, and what that one does is that one just covers the basis of where you can put a marijuana establishment. Basically, a marijuana establishment must be 200 or must be further than 200 feet from a child-centered facility, religious building where worship services are held, or a correctional facility. Must be away from a school, a daycare facility, a church, any regular place of worship, or a correctional facility, right? So now the cool thing about this, in my opinion, is that you will be grandfathered in. So if you have your business someplace and a daycare moves in next door, no effect to you. It's the daycare's choice to locate right next to a marijuana establishment, and that shouldn't be a problem for you, of course. However, if you let your license expire or for some reason it is revoked, then the same rules apply and the daycare will take precedence and you will have to move your facility to another location. So the next thing that kind of brings a little bit of issue with regards to business acumen in this is that section 306.010 letter B says the board will not issue a marijuana establishment license if the license premise will be located in or immediately adjacent to a liquor license premise. Why? That's my question. Why? Why will they not issue a liquor license if it's right next door to, or why will they not issue a marijuana establishment license if it's right next door to a liquor establishment? Doesn't seem to make sense. I mean, all joking aside, but keep all your sin in one place, right? So if a marijuana or if a liquor establishment is allowed to sell cigarettes, why not allow them to be at least located in the same vicinity, the same location, adjacent to, within? What's the concern here? It really makes me wonder about that. Of course, as Section C says, the board will not issue a marijuana establishment when a municipality protests or if local zoning ordinance prohibits it, which makes sense. Section D says the board will not issue a license to a person who is basically convicted of a felony. So I wonder about that. I wonder if that's, again, why? What's the justification for saying we can't issue you a license because you've been convicted of a felony? What felony and why? And according to this, an SIS, or a suspended imposition of sentence, where the individual specifically worked with authorities, worked to get it off their record, worked to do proper things like community service and time served and things like that, and yet they're still being punished for it, just doesn't seem to make sense, especially if that felony happens to be a marijuana-related crime. It just seems very odd in that. So I would wonder about that one in there. Really, what's the point? What's the business industry point of that? Are we just trying to exclude people because they had a previous felony and now they're trying to turn their life around? Or are we trying to do something good for the community? Not sure with that one. Section 2 on that, if you follow down on page 4, says the board will not issue a marijuana establishment license to a person who operated a marijuana delivery service, a marijuana club, or a marijuana establishment illegally without a license within 2 years before the effective date, unless the board finds that person has diligently worked with the board to comply with current laws relating to marijuana. Well, come on, we know who this is written for. We know that this is written for Rocky Burns and Discreet Deliveries. We know this is written for these social clubs that we're unsure of. But what does it mean to diligently work with the board to comply with all current laws? What does that mean? How does that define? And will that be completely up to some personal hatred? Or will that be actually legitimate and make sense? So, some good questions there. So moving on to the license conditions section, 306.015 at the bottom of page 4, basically simply saying that you can have a license issued to a sole proprietor, a partnership, a limited liability partnership, a limited liability corporation, and a corporation. So those entities can all receive licenses. However, there's a statement here that says a person other than a licensee may not have direct or indirect financial interest in the business for which a marijuana establishment is issued. This is a problem. This is a significant business problem that no other business is told where their money's coming from. No other business is told how, where they can get their money. They just get their money, they open, and there's not a morality issue or per se a residency requirement. And so I'm really concerned about that. What's the point? Why? Why limit the money and why limit where it comes from? It still pays taxes, it still creates jobs, and it still betters the economy of Alaska. So why are you requiring that a person who has any type of financial interest must be on the license? I understand making it a part of the business plan and making it disclosed as to where the money might be coming from, just because, but requiring them to qualify for a license says that if they have a felony and they have $1.5 million and they want to invest in a marijuana business, they can't because they couldn't apply for a license. Just doesn't seem right to me. That being said, what about some sort of a compromise? What about saying that that individual who might not be a resident or might have a felony or whatnot may not have a controlling interest in the business? So what's the ways that we can work around that? Because truth is, if they put something like this in the regs, every business owner, including myself, will probably find a way to get around that because it's not fair. It's not fair and it's not smart business-wise. So I would find a way to maybe reword that section particularly. So let's see here, of that section, the board will not issue a license, a marijuana establishment license, unless you're a resident of the state. That is defined by PFD. So if you qualify for the PFD, you would qualify for having a license in the marijuana industry. Again, a residency requirement, I'm not sure. I fully support Alaskan-grown businesses, as Midnight Greenery is an Alaskan-grown business. However, I'm also a free market capitalist. So, if another industry can come, or another individual from another state can come in and do a better business than I can, then that means I need to step up my game and be better and compete better with them. So, it's kind of give and take in that. Not to mention, will a PFD requirement or will a residency requirement stand up in court? The Supreme Court has said that you can't necessarily base a residency requirement on something that you give, something that the state gives to the citizens, i.e. the PFD. And so it's really, again, another gray area that we need to be considerate of with that. All right, so all of that being said, we move on. It discusses that each section, the individual, the sole proprietor, the partnership, the corporations, each of them all have to be residents of the state. Not a controlling interest, but all of them have to be residents of the state. So this says that that investor that wants to invest $1.5 million maybe lives in, I don't know, Colorado, California, Maine, right? Maybe they live in another state, but this requires them to become a resident of Alaska and to enter into a corporation or a business agreement and be an owner of the business that they're investing in. And that's not always the case. And I don't believe it's the spot of the Marijuana Control Board to tell people how to do business. If they want to do it that way, that's their thing, but that shouldn't be required. It shouldn't be that every single business has to do it that way. It just, again, doesn't seem fair. So it goes on to talk about the board will issue each license for a specific location on the licensed premises that will be diagrammed just like a liquor license is. But it also says it may not lease a licensed premises to any other person for any reason. So this says that you can't have any businesses inside of businesses, that it needs to be all within that spot of marijuana only on the licensed premises and only marijuana on the licensed premises. So that is an interesting concept. A marijuana establishment may not relocate its licensed premise to a different place. Any new premises proposed require a new application. So instead of maybe a change of application or a different form, it's a whole brand new application, which, I don't know, give or take. How do you feel about that? Weigh in below for me. So the other statement that I really am concerned about, because it's very vague, is the board will impose other conditions or restrictions on a license issued under this chapter when it finds it is in the interest of the public to do so. That sentence. When it finds it is in the interest of the public to do so. What does that mean? And is that really broad? Could that mean because the executive director of the Marijuana Control Board believes it's in the interest of the public, and yet it's not really, or the public as a whole doesn't feel that way, but they've never been voted on? It's just weird. I don't know. Just something to think about. Okay? So then we move on to page 6. This is, again, the definition here at the top where it talks about direct or indirect financial interest regarding the investors. It says it means a legal or equitable interest in the operation of a business licensed under this title, but it does not include a person's right to receive rental charges for a property or a consulting fee from a licensee for services that are allowed under this chapter. So if I were to have Alaska Green Resources in Kenai, if they were to consult with me, then that would not be considered a direct interest. That is, if they were to consult with me and receive a fee for it, that wouldn't be considered a direct interest. But any other consulting fee might be considered a direct interest because it says a consulting fee from a licensee for services. So if it's a consulting fee for, I don't know, an outside consultant that doesn't have a license but has tremendous horticulture knowledge, is that considered a direct financial interest? Not sure. So then section 2 there states that a resident of the state means a person who meets the residency requirement for an Alaskan permanent fund dividend in the calendar year in which that person applies for a marijuana establishment license under this chapter. Again, it means that the money must come from a resident of the state and one that will qualify for a license application. It's just bad business acumen all the way around. Investors often don't want to be a part of the business license. And sometimes they prefer to be silent too. So no other industry limits where the money comes from, and I'm concerned that this one, if it does, it will really make the elitist of the elite be the ones who can operate a marijuana industry, a marijuana business in this industry. And so, again, I'm a little cautious about that one. All right, so we move on to the bottom of page 6. Application for a new license. An applicant for a new marijuana license shall file an application, of course. That application shall be filed with application fees, the annual license fee, fingerprint cards, and any additional fees. It'll be filed electronically, mailed, or delivered, right? That all seems to make sense, of course. In the application, it must include, and this one I have a significant personal problem with, the name of the proposed license and any business name the licensee will use for proposed marijuana establishment. Right? We got that. Okay, that's fine. Along with the Alaska business license, okay, and the EIN, right? That all makes sense. But here's what doesn't. The name, the mailing address, the phone number, and social security number of the applicant and each family member, and affiliate of the applicant. So I'm a mom, I have a 2-year-old, and I'm married. So each family member would mean that my application would have to state my husband and my child. My 2-year-old child would have to go on the application? That seems quite like government overreach to me, and not fair, and not smart business. No other business requires you to list your child, maybe a security government clearance or something of that nature, but there's no reason that my child's information needs to be on my business application for a license. So again, it goes through to mention if an applicant is a partnership, then it must list the partner's name, their family members, and their affiliates. Same with a limited liability company, same with a corporation. So family members are listed. And I don't think Alaskans are going to be okay with this, that kind of government overreach into your family. Business is family, business isn't personal, and to keep the two separate is extremely important. So I just don't see how that should be in there. Doesn't make sense to me, right? So then we have a section where 3A, for each applicant that is not an individual, the applicant information as follows, becomes information on just business. So 3A seems to completely conflict with 2A requiring family member information. Not really sure what's going on there. So then on page 8, it goes into discussing what needs to be on the license. So we start out with, of course, the business name, the AK business license, the EIN number, the people, the individuals, family members, names of the managers, email address, type of the license you're applying for, the address of the facility, then to include a diagram of the licensed premises, any title or rental agreement for the facility to make sure that you have the ability to be there, the affidavit posting notice that you've applied for an application, and the proof of advertising out in the newspaper or the community or radio, whatnot. And then, of course, additional information per license. Retail requires security plans, whatnot. And then operating plans. These operating plans include things like your security plan, things like inventory tracking, employee qualification and training, waste disposal, transportation delivery of marijuana and marijuana products, and signage and advertising. So those items are things that your business plan are going to have to include, which I think is extremely intelligent because it really makes the individuals who are coming into this industry plan it all out. And every time someone asks me, well, where do I get started? How do I get started in this thing? You write your business plan. You get it out. Get it on paper. Get your vision out there for the world to see so that you know it. Because it's great to have an idea, but unless you've thought all through the details, your idea doesn't seem to work, and it will fizzle. It will fizzle, because when you are hit with a challenge, you don't have a backup plan. So these are ways for backup plans to be covered in that. So also on page 9, there's something that brings up a cause to me. The application for the marijuana establishment license must be signed by the register agent or a member who owns at least 10% of the LLC. 10%. So let's say the application isn't ready. Let's say I feel like, nope, we're almost there, but we need something. But somebody who has 10% ownership in my company can sign that and submit it. Maybe I have 60% ownership in my company, but somebody who has 10% can sign it and submit it. Again, it doesn't seem right. It doesn't seem right at all. All right, and then on page 10, we'll stop at the bottom where for the application procedure, and we'll move on to another time for that. But I did want to reiterate that the definition in Article 9 defines family member, and a family member is defined as a spouse, a domestic partner, a dependent child under 19 years of age or under 23 years of age who is going to school or determined disabled or dependent in some way. Again, I have a huge problem with this family members being required to be listed on the application. It's a violation of our privacy, and I don't feel like it's necessary. It goes beyond a step that government really should be a part of. So that's my cover for today. I will be covering the rest of the regulations as we go through these next couple of weeks. I'll be posting a video every couple of days, just looking through and discussing these things. If you would disagree with me, please put it out there. Let's have a good discussion about this, and let's get the public involved. Bruce Schulte, acting chair of the MCB, said, hey, this is a public process, and we need to get people involved. We need to get people talking about this stuff and not just going, well, whatever they do, they do. We can't do that. We can't just sit around and let them decide this for us. So get involved. Disagree with me or agree with me, I don't care. But get involved, and let's see how this thing goes. All right? I'll see you next time, guys. Bye.